Welcome. On behalf of the Door County League of Women Voters, we thank you for taking the time to come and hear the candidates seeking to become the Branch 1 judge on the Door County Circuit Court. I'm Ann Schmakel, and I'm a member of the League of Women Voters of Door County. Candidate forums, like this one, are part of the Door County League's nonpartisan mission to inform voters about candidates and elections in a civil, unbiased, and nonpartisan manner. Now, let me introduce the candidates running to become the next judge on the Door County Circuit Court Branch 1. They are Jennifer Moeller and Brett Reetz.
I'm going to stand.
We thank the candidates for running for Circuit Court and for agreeing to take part in this forum. In a few minutes, they will introduce themselves and talk about why they are running for this important position. We also want to acknowledge and thank Door County's ADRC Director, Jennifer Fitzgerald, and her staff for allowing us to use their facility. The League of Women Voters of Door County began in 1952. We are one of 21 chapters in Wisconsin and one of hundreds across the country, aligned with the National League, which, by the way, celebrated its 100th birthday in 2020. The League of Women Voters is nonpartisan and never supports or opposes any political party or candidate. However, we are also a political organization of women and men dedicated to encouraging and promoting good government through informed, active participation at all levels of our government, local, state, and national. We seek to empower voters through activities such as candidate forums and voter registration. We also study and advocate on governmental, legislative, political, social, and environmental issues that impact our local communities. The League of Women Voters Door County actively works to eliminate any and all barriers to full participation within our organization, our elected governing bodies, and in the voting process and elections. Our core message is, democracy is not a spectator sport, and we urge you to all get in the game. We also encourage all Door County citizens, regardless of political affiliation, to consider joining the League and to help shape our efforts and advocacy. More information about the League can be found on the display table, along with a sign-up sheet to indicate if you'd like to receive updates of League activities. Please check our website at lwvdoorcounty.org or on Facebook. The website has recordings of previous forums, along with lots of information about voting and League events and information. At our events, we recognize the indigenous people who preceded us. Door County, along with the lands our facilities and parks are located on, are the ancestral homes of the Menominee Nation. Currently, there are 11 federally recognized Native American sovereign nations in Wisconsin. We acknowledge these indigenous communities who have stewarded this land through the generations and pay respect to their elders past and present. Coincidentally, today, February 15th in 1837, the Treaty of the Cedars was proclaimed, requiring Menominee Indians to move from the Door Peninsula to west of the Wolf River. As to our candidate forums, the views expressed are solely those of the candidates and not of the League of Women Voters of Door County. This forum is not an endorsement of any candidate. Our forums are recorded. Tonight's event will be posted as soon as possible on the League of Women Voters Door County website, lwvdoorcounty.org, and our Facebook page. We encourage all of you, candidates and the public, to spread the word and encourage others to view the recording. The forum will consist of anonymous written questions and candidates' responses. On these question cards, we encourage you to ask questions about topics of concern. The cards are on your table. Questions must be relevant to the court and the work of circuit court judges. The Wisconsin Circuit Court fact sheet you received when you came in can be helpful in this regard. Questions must focus on issues and topics, not on any specific candidate. Please use a separate card for each question you ask. When you finish writing your question, raise your card. Runners will pick them up. Each question will be addressed by both candidates. A question posed to only one candidate will not be used. Questions need to be worded in a way that is unbiased and concise. Our question screeners will select questions covering a variety of issues. Finally, the League of Women Voters of Door County prides itself on organizing and moderating forums that are fair and nonpartisan. We expect, and have never been disappointed, that the civil manner in which the candidates and the public will conduct themselves. We know that that code of conduct will be upheld here tonight. Because this is a forum and not a debate, the candidates have been instructed to only speak about and for themselves, their positions and ideas, not about each other. The moderator will promote a civil atmosphere in which all candidates can respond to each question effectively. Toward that goal, we ask that there be no response to candidates' answers, no comments, cheering, jeering, or clapping, or any other form of demonstration. Thank you. Now, I want to introduce tonight's forum moderator, League of Women Voters Door County Chairperson, Susan Kohout.
Welcome. All right, the candidates, as we have already stated, this will be a forum, not a debate. Each candidate is offered equal time to present their responses. The candidates have agreed to the following guidelines. They will introduce themselves in 2-minute opening statements. Each candidate will then be given up to 2 minutes to answer each question. Each question will be posed to both candidates. However, a candidate may decline to answer any question. No question will be directed to any one person. Each candidate will then have up to 3 minutes for a closing statement. The candidates have drawn straws to determine, actually I think it was rolling a dice, but they have done so to determine who will speak first, after which the order of speaking will be alternated. League screeners will review the written questions submitted to eliminate redundancies and inappropriate questions. If the screeners do not understand the question, it will not be asked. If used, questions will be asked as written. A copy of all submitted questions will be sent to the candidates after the forum so they can see the concerns of all who attended. Candidates, please note our timekeepers. They will signal you when you have 30 seconds remaining in your response, and again when it is time to stop. We ask that you conclude your thought and stop when signaled. No personal flash cameras, video cameras, or other visual or sound recording devices are allowed to be used during the forum except by the press media. Candidates, you may not use any audio or video from the forum in or for commercial advertising. We will ask questions until approximately 7:15 or until we run out of questions, whichever comes first. And then candidates will be able to make their closing remarks. So we will now hear opening statements from the candidates, and we will begin with Mr. Reetz.
Thank you. Can everyone hear me? Still can't hear? You cannot hear me? Oh, you can. Okay, great. Thank you all for coming out. I'm Brett Reetz, and I'm running for judge. The question that gets begged is why? And my answer is that I've been in this community 32 years. I've been a trial lawyer for 32 years, And this community has blessed me in so many ways. I've had a wonderful life. I have a wonderful family. My kids have been brought up in a wonderful place. And I've just received a tremendous benefit from this community. And it is time for me to give back. There's another reason I want to run is that, and three of them actually, and they're sitting in this audience. We have Judge Ehlers, Judge Dilts, and Judge Weber. I have been in a tremendous amount of courtrooms, well over 100 different courtrooms. I've been in front of hundreds of judges in all over Wisconsin, Florida, Michigan, Illinois, Collier counties of Chicago. I've been in front of a lot of judges. So I think I'm a good judge of judges. And I will tell you that I don't always like these guys' decisions, but I don't disagree with them. I've tried to think of a single decision I ever disagreed with, and I couldn't find one. They are always compassionate judges. They are firm when they need to be firm. They're harsh when they need to be harsh, but we're always respectful. It was always and is always a pleasure to practice law in Door County because of these judges. I'm not sure this community recognizes how fortunate we've been to have such fine jurists in this country, in this county. Now, on that note, I would like to continue that tradition. I would like to be the judge. As I said, I've got 32 years of experience. I've tried numerous juries, approximately 50. I have been in numerous courtrooms, federal court, state court, appellate court, the Supreme Court of Wisconsin, and my experience is diverse and broad, from criminal felonies to personal injury to family law to custody. And for those reasons, I'd ask that you vote for me for judge. Thank you.
Ms. Miller.
Thank you. Good evening, everyone. I'm Jennifer Miller, and I'm running for judge. Thank you for coming. Thank you, League of Women Voters, for organizing this forum. My husband, Mark, and I have been members of the League and for years to support voter education efforts like this. They help voters, and they help candidates, too. And thank you, Door County and ADRC staff, for hosting us. My legal career began almost 30 years ago. For 17 years, I worked in the private sector, serving clients, helping them work through whatever legal problems they faced. And for the last 13 years, I have served as the Family Court Commissioner and Register and Probate for Door County. I was honored to be appointed by Judge Ehlers and Judge Dilts. In addition to family matters and probate cases, when the court calendars are tight for the judges, I assist with some criminal matters such as bail and bond hearings, preliminary hearings and felony matters, and review of search warrants. At times, I review and hear restraining orders. I enjoy the variety of court work. In the first years, making challenging decisions affecting people's lives as a court commissioner, I came to know that I'm well suited for this job. It's much like that of a judge. I have the temperament and demeanor required to respectfully listen to everyone involved in a case, thoughtfully make well-informed decisions, and communicate those decisions. I strive for a courtroom that is a place of respect for the law and for all people. I look forward to continuing to serve the people of Door County as judge.
Thank you. Candidates, because we're having some difficulty with hearing, would you please remain seated, and would you hold the microphone up to your mouth when you speak? And hopefully that will help the folks in the back. Okay. For this question, we will begin with Ms. Miller. How do you view the role of a judge and the judiciary in society?
Oh, gosh. Wonderful. Okay. A judge is a leader in this community. People do look up to judges and respect them. Oh, okay. All right, it's right there. Okay. All right. And I've given a lot of thought to that. I touched on that in my opening statements, creating a courtroom that is respectful to everybody who enters. Because to come to a good judgment, you have to hear from the parties, their attorneys, all of the witnesses. They have to be comfortable there sharing their stories, knowing that they will be heard. So that is an important role in the courtroom that expands to the community. And that leadership role is important for bringing people together. There are times, and I've again seen our judges do that here, particularly with the development of treatment court. That was bringing together a lot of people in the community to make something like that happen. That wasn't just for the court. People in the community recognized that that was necessary. So the leadership role of the judge in the community, I think, is most visible. That's what comes to mind when I think of a judge in the community.
Mr. Reetz?
Thank you. The judiciary is a part of our system to the extent that we have a legislative branch, executive branch, and a judicial branch, and it trickles all the way down to the circuit court level. It is a judge's role to enforce laws and apply laws equitably and fairly and universally to equal people. It's a critical factor that people have faith in what a judge does and how he rules and how he makes decisions, or she makes those decisions, because if they lose faith in the judiciary, they lose faith in everything else. Jennifer's right about leadership as well. There's, pursuant to the Supreme Court Code and the Judicial Code of Ethics, judges are required to avoid appearances of impropriety and to maintain themselves in a professional manner. And that does equate to being respectful in a courtroom and managing a courtroom in a professional, respectful way. You are deciding people's futures, not their entire futures, but oftentimes monetary issues, custody issues, whether someone's incarcerated or not. It is a big moment in a person's life when they're in front of a courtroom. And it is imperative that a judge listen and be fair, unbiased when they listen, and play that role as both a leader but as a judge, and have the guts and the strength and the confidence to rule, even though you know you're going to hurt someone's feelings or let someone down or disappoint someone, which is oftentimes the case. Usually in courts, it's not a tie as often as somebody prevails and someone doesn't. So it's imperative to our society, to a civil society, to have a judiciary, and that's the role of a judge. Thank you.
Thank you. For the next question, we'll begin with Mr. Reetz. What are the most pressing community issues related to the courts and law enforcement?
I do about 60% criminal defense. And in fact, the courts, when you look at the numbers in terms of courtroom activity, it's in that same range in terms of what takes up the time of the judges. It's about 60% criminal. Throughout my cases, I would say approximately 85 to 90% of my cases involve drug addiction, alcoholism, or mental health. Those three issues combined, call them all mental health issues, if you will, that is the biggest issue in our community right now. Crystal methamphetamine is devastating people's lives. It is prevalent in our community. It is just leaving a debris field of people, and not just the users' lives, but other people's lives. And the judges have to be able to address that issue in a constructive way because it is really devastating our community. Mental health, too. I have spoken to Colleen, I've spoken to Joe Kreschbach, too, and indicated that there's a need for a mental health court and a veterans court and even an alcohol court like they have in Brown County. There's a funding issue, but I've spoken to the district attorney, and we thought we could maybe address that through what they call deferred prosecution agreements, which would be akin to a sort of a private agreement that contemplates those issues with defendants. It's imperative that these people get help through the system, and the judiciary can certainly lead and guide them in a positive way, to help them seek recovery and improve their lives, and it'll be a benefit to society. It'll cut down on incarceration time costs, and you'll get successful people out of a situation that seems hopeless for a lot of people. Thank you.
Ms. Miller?
Thank you.
Can we ask the candidates again?
Mm-hmm.
It's uncomfortable, but right up next to your lips.
Okay.
And we also, anyone who wishes, feel free to bring your chairs up closer, and if you need some help with that, just raise your hand, we'll do that.
Okay. So whatever issues the society is facing, those are coming to court. That's what we're seeing. Yes, we are seeing mental health issues, drug and alcohol issues, everything that you see in society that's a priority is affecting us in the courts. And that is something that our current judges have been working on. We have a treatment court, and the Department of Health and Human Services has been looking at a mental health court. Law enforcement officers, jailers will tell you that's what they're seeing as well. That's a huge part of the people that they deal with. As far as funding, just this morning I heard on the radio that Andre Jacques and had some bills that were passed. There is an increase in funds. The state of Wisconsin is supporting these specialty courts. So we have a treatment court, and I do believe a mental health court will be next, will be needed. I have a great deal of experience with the mental health cases. As register and probate, I do work with guardianship cases and the mental health cases, working with the social workers and the doctors, and having a familiarity with those cases. Even though the judges decide those cases in court, I feel like I have a strong basis for that. And that's the other issue, that a judge has to adapt to what the society is facing. And that's one of the things I've enjoyed about practicing law. You have to adapt to what your client's needs are, or whatever environment you're in, as well as the law is changing. But thankfully, the state of Wisconsin is recognizing that those specialty courts are important and funding them.
Thank you. The next question, we will begin with Ms. Miller. How do you plan to manage a caseload and prioritize cases?
I'm very familiar with that, thankfully, from working the last 13 years
Excuse
within.
me, I hate to bother you again, but we're going to ask you to stand
Sure.
and try holding it up. And truly move. I mean, we are using the system of this building, and Laddie is recording this, so that the feed goes straight to him for that. But in terms of you hearing us, we're using the building's system, and that's where we are. So please, stand and right up to the.
And I
Thank
need that
you.
question again, please.
Yes, I will, and we will start over with timing.
I will. Yep.
Okay, how do you plan to manage a caseload and prioritize cases?
Okay. I've been working in the court system for the last 13 years, and I've managed my calendar myself, which actually wasn't so different than a busy attorney's calendar, trying to juggle everything. The difference is, for a judge, I'd have a judicial assistant working full-time, helping me with my calendar. But any judge in Door County hears all of the cases, everything. They're going to have a mental commitment. They're going to have criminal cases, divorces, everything sometimes in the same day, and having to switch gears and fit things in where is necessary, where is needed. So my breadth of experience will help me to switch gears, because that's what I did in private practice, and that's what I'll be able to do for on the bench. Working efficiently too. I am very passionate about moving cases along at a reasonable rate, because I know from when I represented clients that oftentimes delays did not serve anybody involved. So the ability to work efficiently, which I have from my court commissioner work and from my days in private practice, will help me manage my calendar.
Mr. Reetz. So we're having you stand back up.
Back up. All right. I'll give it an easy first part of the answer is I like to get up early, and I would start early in the morning. But I'm very aware of the different types of cases, because I've handled just about all the different types of cases. Certainly people in who are incarcerated generally are given a priority to have a trial date. If someone's out on bond, it's not so urgent. Then you have to coordinate speedy trial demands with that, and then you have to coordinate trial lengths. If you have a one-day trial versus a 5-day trial, it eats up a lot of time. And so my office is very efficient and always has been at calendaring and scheduling. We're versed, just as the court has to calendar, so does the private lawyer. And we have to do the work as well to prepare for trial and those types of things. So I definitely have the skill set to juggle calendars or organize calendars to be efficient and effective. And also, additionally, just in terms of hearing times and things like that, and condensing, having sort of the same theme, like a divorce day or a family law day, which the courts do, that helps a lot. Also encouraging settlement in civil cases by pushing people into mediation or having discussions within the courtroom in terms of settlement on civil cases to resolve the cases. By giving clarity from the bench in a civil case of your intended direction or your thoughts on a case, you can oftentimes encourage settlement because the clients and the lawyers are listening to that. So the answer to the question is, how do you manage a caseload? You do the work, you get to work early, you schedule appropriately, you communicate well with the litigants, whether they be criminal or civil or family law matters or pro se, and you can make demands of the attorneys to get the job done as well, and you should. And everyone appreciates it in the end. Lawyers generally want to get their case done with, and if a judge helps them along, they can blame it on him. Thank you.
Thank you. For the next question, we'll begin with Mr. Reetz. What is your approach to dealing with difficult or controversial cases?
Well, they just described almost all of my cases. So the people are difficult. People do not come to lawyers or get into court when things are going well, for the most part. The vast amount of time. Very few people go to court for good news. So that I'm constantly dealing with difficult cases. People are facing prison. People are facing loss. People are facing losing their kids. Kids are facing losing their parents. So my style is, or my technique is, that I'm honest. I'm very honest with people. I tell my clients, and I would tell anybody, I tell people I talk to, you don't pay me to be nice, you pay me to tell you the truth. And in terms of difficult clients in the courtroom, difficult litigants in the courtroom, or difficult lawyers for that matter, you've just got to be firm. You've got to address them. You've got to be unafraid to tell the truth of the weakness or strength of their case. You need to communicate and not be afraid or in any way let your opinions and what you state be influenced by the fact that the person on the other side that's hearing it is going to react adversely or scream or yell or be angry or dislike you. The truth is golden, and you don't ever have to be ashamed of telling the truth, and you shouldn't be afraid of telling the truth as well. So it's a question that just sort of has a simple answer. Most people in courtrooms, most clients are difficult, and the way you get around that is you just look them in the eye and you tell them what the deal is. You be honest. Honesty gets through that.
Okay, Ms. Miller?
Thank you. Difficult or controversial cases, you don't change your approach necessarily for the case. All cases, I remain calm. I too have experience with difficult cases. I'm in family court. Those are divorces and paternities. People are very passionate about what's going to happen to their children, to their retirement account, who's going to pay the bills. It's very tense, very serious for them, very difficult for the litigants. So that's part of courtroom control, remaining calm, even when people are getting along better than others, doing that in every single case. Not necessarily changing course. We want to hear the facts. We want to know the law. We want to apply the facts to the law. Apply the law to the facts at hand. The law gives you a grounding. That rule of law, you're looking to the law, what the statute says, perhaps what the Supreme Court or the Court of Appeals say if you need to, not getting sidetracked by whatever might be difficult or controversial. So I have that experience with directing people, and sometimes it's taking a few moments, letting them blow off some steam. We can do that in family court a little bit. People want to be heard. So we let them be heard respectfully, and then we handle the case the way we would handle any other type of case, whether it's family, probate, where somebody has died, whether there's a mental health issue, or a criminal sentencing where emotions also run high. Thank you.
Thank you. For the next question, we will begin with Ms. Miller. How do you stay informed and up to date on legal developments and changes in the law?
We're fortunate to have a number of resources. I mean, all attorneys in the state of Wisconsin are members of the Wisconsin Bar Association. So they put out publications, monthly and weekly email blasts. Also, judges have some legislative updates that we get from the Director of State Courts office, and the court commissioner gets those as well. I subscribe to the Wheeler report, so I can keep track of legislation that's pending the best I can, because legislation's always changing until it's signed into law, or until it's voted on and then signed into law. So we have a lot of good resources at our disposal. The judicial state judicial education system is fantastic. I avail myself of that. I've been involved in presenting at judicial conference as well, and taking advantage of our peers. So that's a great resource that judges have, is working with our peers as well. But staying informed, yeah, that's a big part of the job, and we have the tools at our disposal, and I'm experienced in using those.
Mr. Reetz.
Jennifer's correct. The Wisconsin Bar Association has feeds new cases, new developments in law, so that's one news source. Just the news is another news source. Following the legislature is another way to obtain information regarding changes. And in addition to that, let me think if there's anything else I seek. We get seminars. Oh yes, legal seminars is a way to do it, and there are judicial seminars as well. And so that is not a weakness of the judiciary, is understanding impending changes, and new laws. So it's really a rather easy question. It's not hard to stay up to date on the law.
Thank you. The next question, we begin with Mr. Reetz. Some legal experts maintain that judges have a duty to maintain literacy in tech talk to perform judicial duties competently. How well prepared are you to understand newly evolving tech talk that includes memes, emojis, and other symbols of communication?
Well, that's an interesting question. I understand tech. I actually am a part owner of a social media company, so every Tuesday night I spend 2 hours talking to techies on Zoom. In terms of memes, Facebook, social media, those sorts of things, those are sort of a new lurking creature in law. It is. I've done this a few times in trials where suddenly Facebook postings pop up as evidence found late in the day, and you're unprepared for it, or you are prepared for it, and the other side's unprepared for it. So memes, Facebook posting, Snapchat, texting, you need to be familiar with that. You need to be, and I am, you need to be familiar with screenshots of text messages. Text messages are used in evidence all the time. Emails are important. It is amazing how much evidence is garnered from social media and electronic communications. It's imperative that you are aware of it, stay up to speed, understand how to make evidentiary rules on preparing proper foundations for that type of evidence, and just be familiar with it, because it is a critical part of litigation and courtroom activities in a lot of different cases, from contract to family law to criminal law as well.
Ms. Miller?
As I mentioned earlier, whatever is going on in the community and in society, that's what we're seeing in court. So yes, technology has been coming into the court. It's been a challenge adapting the evidentiary standards and laws that we have for some people to technology, but you still need a foundation to get that evidence in. Unfortunately, with the speed at which some of this information is going back and forth, we get huge piles of text messages, screenshots, and emails that come in, particularly in family court. So I've been seeing that. And again, the judicial education has been on top of that, keeping us up to date, but just, again, reminding what does the law say on this, and the law is catching up on some of the technology, but those rules of evidence still apply, still are a foundation. But what really not fascinates me, but I don't hear as much about it, is the risks, the facsimiles, not necessarily talking about AI or things like that, although that's something that we have to be aware of as well, but how somebody could manipulate an image or data, and how we can be sure that that's reliable before it's admissible. So yeah, we're on that, and there will continue to be education. Again, that's what makes it an interesting job as things change in society, and we're always learning and growing, and I like that about this job too.
Thank you. For the next question, we'll begin with Ms. Miller. What factors would you consider in adjudicating Chapter 51 involuntary mental health commitments? Okay. Well, thankfully, that's one of the things I do as I'm involved in as the register in probate. So mental health commitment cases, that's an emergency situation. It's usually a law enforcement officer that gets a call. Could be from a friend or a family member. The social workers are involved with that too. And the question is somebody a danger to themselves or others? For a mental health commitment, do they have a mental illness? And is it treatable? Will they benefit from treatment of a commitment? A common misconception when you hear commitment, and some of these are for 6 months, people think committed to a facility. Somebody might be at a facility for short-term intervention for their safety, but the goal is to release them to the community, and we have social workers here in Door County, every county does, to get the people back into the community, get their lives back to normal, because mental health is prevalent and a lot of it is treatable, and it's getting people to the treatment and getting their medications where they need to be if that's what part of the treatment is. So those are the 3 standards that you consider. And very quickly, I mean, somebody's taken into custody, we take it very seriously, we go very quickly, because they're locked up for all intents and purposes. If you're at a mental health facility, you may feel like you're in a jail. So we're gonna get those, well, the law says you have to get those heard within 72 hours, there's a probable cause hearing, and within 14 days, there's a final determination on whether somebody's gonna tell me or you or somebody else whether they have to work with the social workers and maybe even be told whether they have to take medication as well. Thank you. Mr. Reetz?
The primary factors are whether they're a danger to themselves or a danger to others. Secondary factors to whether or not there's an adequate facility to care for them. They do require strict attention to those cases. There are statutory time limits, and it's just imperative that you hold the petitioner, the person seeking the commitment, whether it be the sheriff's department or a doctor or a family member, whoever it might be, to that burden to show that this person is in need of assistance and that mental health assistance, and that they are a danger to themselves or a danger to others, and then to get them into the appropriate facilities. I've been involved in a number of these, and they're tough. They're tough on the respondent, the person they're trying to commit, and but when it's done appropriately and when it works, and the person gets into the treatment and gets out, it's for the better, and it's for their own protection. So the standards are set forth by the statute, and it's not, as a judge, certainly you interpret the evidence, but you apply the same law in each case.
Thank you. For the next question, we will begin with Mr. Reetz. How do each of you feel about second chances for domestic abusers and sex offenders?
That is a tough question, and it's a question I ask myself a lot. I believe in second chances generally. People fail. I have statements I make that a person falls down. A failure is not someone who fails, it's someone who fails to get back up. But when you're dealing with domestic abuse cases and somebody who is battering a spouse, you wonder, have they crossed a line where they can't be rehabilitated? Well, the truth of the matter is that they can be rehabilitated, but not all of them. Obviously, we have recidivism. So in order to, in terms of domestic violence and spousal abuse, that sort of thing, in that sense, I think sanctions are a good help a lot to encourage a person to not reoffend, whether it be jail or a restraining order. Those things are effective. Also, you need to guide people into counseling, anger management, alternatives to violence programs, which are offered in the community. That's asked to that. In terms of sex offenders, I come down harder on those folks. That's a crime that is what we call mens rea. It has evil intent. It's not speeding and just against the law because the government says it is. There's an evil intent to sex offense cases, sexual offenders. And that one, my position is that in those cases, more incarceration, intensive rehabilitation, and then intensive supervision post-incarceration, because when someone is so wrong in the way they are, that they are sexually assaulting people, molesting children, sexually assaulting children, I want a sentence that ensures that person knows that they're to the extent that there may not be a second chance for those people if they reoffend.
Thank you. Ms. Miller?
Thank you. I believe the question was how do you feel?
Would you like me to repeat it?
No, I'm fine.
Okay.
Thank you. But I did hear the word feel about second chances, but domestic abuse and sex offenders. Of course, we all feel outrage on about those two issues. Again, training, but also from experience working with offenders as well as people who have been abused. So again, judges receive training on both of those. But how I feel about it, that outrage that I might have, I have to temper that if I'm judging. And it's also case specific. What has the person been charged with? What does the law say? Not every case is the same, even though those are two outrageous or concerning types of cases. So it's not just what I feel. I have to hear from the district attorney. I have to hear from defense counsel. Have to hear from the defendant. What does the victim of the crime say if there is a victim that's willing to participate? If they're given that opportunity, can't take that lightly. Have to listen to all of those things when I make my decision. Case specific, what does the law say? What is the maximum, minimum penalties? It's hard to say whether a second offense would be appropriate for either of those things, but I could only determine that after I hear from all of those other people that I have to consider what they have to say before entering judgment and a sentence in those crimes. Thank you.
Thank you. For the next question, we'll begin with Ms. Miller. Would you pledge to step aside from a case when your impartiality might be reasonably questioned, or when you or your spouse have a financial interest in the dispute?
There is a fantastic code of judicial conduct that guides judges I've been working under that code as a court commissioner for 13 years. So that is something I consult regularly. The pledging to step aside, again, it's case by case. It's specific, the facts to that case. If I don't think I can be fair and impartial, well, that's the basis of being a judge, so I would have to step aside. Does somebody else think that? Are there other things going on in the case? I cannot tell you that I'm going to step aside in every case that somebody else is going to suggest that I can't do that. But if I don't believe I can be fair and impartial, of course, I need to do that. I don't take that lightly. I know that that's the basis of the system of law that we want people to respect. We're part of the government. We're upholding the laws of the state of Wisconsin, the law of the land. So I would never do anything that would threaten that. So I'd have to see what the facts of that case are before I could answer that. Thank you.
Mr. Reetz.
Thank you. I would certainly recuse myself if I didn't think I could be objective. That's an easy question. The Supreme Court Code of Judicial Ethics is really clear on recusal. It's a big question in terms of campaign donors, to relatives, to having been a former, having a litigant in front of you as a former partner, or a person in front of you that you represented at one time. So those questions depends on the case, those questions. But when it comes to financial interest, you don't have a choice as a judge. If you have a financial interest, if your spouse has a financial interest, if your children have a financial interest, and even if a relative once removed from that situation has a financial interest, you're required to recuse yourself at that time. There is some gray, some subjectivity in recusal if, for example, you represented the person that's one of the litigants. If a lawyer made a request for recusal, I would honor that request. The judge's job is to maintain an appearance of impropriety. They cannot come across as being biased. If the court gets an image of being biased, it crumbles. So in terms of recusal and stepping aside in situations where it appeared that I could be biased or prejudiced, or I would be committing an impropriety by ruling on that case, I would definitely step aside. If there's a financial interest, either direct or tertiary, the law requires me to step aside, and I would certainly do that.
Thank you. For the next question, we will begin with Mr. Reetz. As the position of circuit court judge is nonpartisan, give examples of how you may strive to not be biased towards interests or pressures from political parties.
Well, first off, I'm not a member of any political party, and that goes a long way to not being biased or political. But more importantly, our nation is built on a nation of laws, not men, not ideologies, laws. And the judiciary maintains those laws. In terms of my politics or my beliefs, whether they be with guns or abortion or taxation or the size of government, it's my job as a judge to follow the law. Judges don't make laws. I do not believe in judicial activism. Judges do consider public policy. For example, in family law cases, it's public policy to look out for the best interests of the children and stability of the family. Those are public policies. But judicial activism or making new law is an improper role of a circuit court judge. We don't make the laws, we interpret the laws, and we apply the laws. So in keeping politics out of it or personal opinions out of it, that's rather easy for me. My duty is to follow the law, and I have so much respect for the law and our system and the freedom we have based on the fact that we do follow the law, and we are a nation of laws, not men. That would hold me to that duty. It'd be very easy for me, it will be easy for me to adhere to that duty.
Ms. Miller?
It's a question of bias. And we do have to recognize that we're human beings, and you have to be vigilant. We're not computers. We have to be vigilant against bias and try to recognize it even when it's not obvious. So that is not just partisan issues, it's all issues. That's judging all, a system of by and for the people. As Mr. Reetz mentioned, we're following the laws, and those are made in Madison for the most part, the statutes that we're following. I never know whether it's a Republican legislature that passed it, whether it's a Democratic governor that signed it, because the laws that we're working under, some of them were passed over 100 years ago. They've been updated over the years. And what many legislators will tell you, that a vast majority of them are have bipartisan support. So I don't even give that any thought either. But that is, I think, perhaps applying to people who are in front of you. You're treating people fairly. You're listening to the facts of the case. You're applying the law, and you're treating all people with respect and hearing them out and making your decision accordingly. Thank you.
Thank you. For the next question, we begin with Ms. Miller. What role should our judicial system play in combating alcoholism when there are so few resources available to turn to?
Well, the judicial system has to deal with it. That is involved in many crimes. We have crimes involving alcohol or are operating while intoxicated offenders. They're a big part of our jail population. So we have to be involved in it. As far as combating it, we give our sentences, but that's where that leadership piece and working with the community, which is ideal through treatment court and the CJCC, Community Justice, there's a collaborative group, bringing different people in the community to the table to address issues that affect the court. So working on that, working with Health and Human Services as our system currently does, and we know it's a challenge. It's a challenge for them, for us, but treatment is part of that, and the education on how we can best treat individuals. It's something that we're doing, and could we do a better job? Yes, our community could do a better job as well. I mean, some of it's funding, but we do the best with what we have. Thank you.
Mr. Reetz.
Well, alcoholism is a serious disease. It's involved in a large amount of my cases where my clients are intoxicated. I defend a lot of drunk drivers. A lot of domestic cases have alcohol involved. So it is something the judiciary, the bench should deal with, and it does deal with it. Could it do a better job? Of course. We can always, I don't think I've ever done anything in life that I couldn't do better. What needs to happen is some understanding from the bench, and it happens, but an understanding from the bench that these people have a disease, that they need treatment, but they also have to take personal responsibility. A doctor doesn't fix an alcoholic fixes an alcoholic. The person who's an alcoholic makes that choice. They hit their bottom. Very often that bottom is right there in the courtroom, right in front of the judge. And by crafting or encouraging district attorneys and defense attorneys to craft creative solutions, creative resolutions that aren't just jail time or probation, but also have some mandates for treatment and reporting to probation that they are going through treatment, and then reporting to the court even that they're complying. One of the things I would like to do, which they do in Kewaunee County, there are probation reviews, where the relationship the defendant has is not just with his probation agent, but also with the judge. And that, in terms of alcoholism or drug addiction, that puts an additional burden, another responsibility that person will violate if they fall off the wagon or if they choose to reuse. So we can address it, we do address it, we can do a better job with a more intimate relationship between the bench and the victims or the people suffering from the disease of alcoholism.
Thank you. For the next question, we'll begin with Mr. Reetz. How would you handle a situation where a party was not represented by counsel?
That happens a lot. That happens, smaller cases, that happens a lot. I'm very familiar with that situation. As a lawyer, I'm actually somewhat nervous when I'm against a pro se litigant because they don't always lose. They don't always lose. It's the job of the judge to make sure that the procedure is fair. And of course, that's an obvious statement. But with a pro se litigant, they don't have the legal skills that the lawyer has on the other side. So it's my position that a judge should give a little bit more deference and leeway to the pro se litigant, not hold that person to the same standards they would a lawyer. I'm not saying bend the rules substantially, but treat that person with a little deference to their, I don't use this word derogatorily, but to their ignorance of the system, so that you can ensure justice even if the pro se litigant doesn't articulate their arguments or their statements or their evidence in a professional, lawyerly way. You need to, they're people too, and just because they don't have a lawyer doesn't mean they don't have a right to justice. So as a judge, if I have a pro se litigant, I will make sure that that person gets a fair day in trial. And despite their lack of legal knowledge, I would let them and assist them as much as I could as a judge, being unbiased, so they could present their case and then determine the outcome accordingly.
Ms. Miller.
Thank you. This is something that I encounter every day in family court and in probate court, people that are not represented. My communication skills help me remaining calm as best I can most days, helps me tremendously to help the individuals there, to give them some direction for better outcomes. Again, big part of my day as a court commissioner is family court and probate, and those are courts of equity. We want the best outcome in family court for everybody, but we're talking about children and the best interest of children. So we're not going to have some harsh rule that we're not going to let them speak to figure out the best possible way to have them present their case without representing them. Again, there's a code of judicial conduct does give us some guidance on how we can do that, how we can walk that difficult line. But I've been doing that. And one of the things I've also been able to do as court commissioner, and our clerk of court does it as well, directing people to resources. Sometimes the judges for family court, in family court will direct parties to me. The clerk of court is very knowledgeable. The deputy clerks of court help guide people in the process, because that is often what is the challenging thing for individuals. The Wisconsin court system has a fantastic website with lots of resources there. We're also fortunate in Door County to have Legal Aid Society of Door County to assist some individuals. So we do not hesitate to direct people to those resources. But again, getting the best possible outcome in court, hearing the person out, remaining calm, and we get the job done. Thank you.
Thank you. The next question, we begin with Ms. Miller. How would you handle a situation where your personal beliefs conflict with established law or legal precedent?
Okay. So that happens. It's already happened as an attorney, as a family court commissioner. I don't agree with every single law that comes out of Madison, and it doesn't matter. So I have the experience for almost 30 years now as an attorney, as a commissioner, of following what the law is. So that isn't a challenge to me. That's the heart of what we do for every single case. So whether it's my personal belief, again, doesn't matter. I'm applying the law to the facts at hand. So I don't find that to be challenging, and I haven't found that to be challenging as a court commissioner. As a young attorney, there were times that it was difficult, and where I found the guidance was in the statutes. That really grounds me to analyze the case and move forward. Thank you.
Mr. Reetz.
It is rather easy. There are a lot of laws I disagree with, but the thing I do is I cherish their system of laws. So it's an easy answer in that you would just follow the law. The fact that I don't like a law would not influence my decision as to that law because of the priority I put on our system and how well it works. It happens all the time with certain issues, from divorce to DNR regulations. I'm a deer hunter. My boys deer hunt. We constantly are against those rules, but they're the law. And even though we don't agree with the law, we comply with the laws because we respect the system of laws. That's not a difficult challenge for a judge, for me anyway. Thank you.
Thank you. For the next question, we begin with Mr. Reetz. What is your approach toward interpreting laws that might be ambiguous or open-ended?
That's a law school question in some respects. There are some laws that are uncertain. I argued a case once in front of Judge Kane where we argued about the placement of a comma. And I won, but then I was appealed and I lost. So with laws, you look to the legislative history. You look to case law interpretations. So you do your research. It's very easy to do research now. The WISPAR has very, very capable software system to find case law. Legislative history is very much available. And from those sources, it can lead you to other sources. But when you read laws that are confusing or that are argued one way, and oftentimes you're debating or you're deciding between two lawyers debating about the meaning of the law. And that's where you go to the books. You go to the books to interpret those laws, you read case law, and you reconcile all that to come up with an opinion. Very common challenge. Thank you.
Ms. Miller.
My answer is similar. We have our guidance from the laws. There often is helpful information from the Court of Appeals and the Supreme Court. We take arguments from the attorneys before us. Often that's based on Court of Appeals and the Supreme Court. It's very interesting. And as Mr. Reetz said, sometimes as a judge, the Court of Appeals might have a different position. But there is information that we can consult. The legislative history in particular, there's usually quite a bit there. As I mentioned, the different versions of laws that go through the legislature before it's signed into law, before it's voted on and signed into law. So you can see perhaps what was struck and what was inserted. So that can kind of help you as well when you're doing the tough job, interesting job of interpreting the laws.
Thank you. This will be the last question before closing statements, and we will begin with Ms. Miller. What role will empathy play in your decision-making process as judge?
Empathy is an important part of a judge's job. I have seen many judges in my career, both in the Milwaukee area where I started practicing law and then in northeastern Wisconsin. And I've seen it done. I've seen it done well using empathy. And I was thinking about this last week. It was my birthday, and somebody wrote in my card that I was the kindest person they knew, which floored me. But I thought it was the kindest person I knew was the one that gave me that card too. And as an attorney, you don't always want to hear that, or a court commissioner. But I know that people appreciate it. When they're in court and they're treated with respect, that's a form of kindness. It also reminds me of a meme about not mistaking kindness for weakness. It can be done. You can be kind and respectful to people. It could be any one of us in court for any reason. So kindness and empathy, I think, are important. Could be anybody walking in those shoes. So I do think you get a lot of respect, because I've seen that from clients who've gone to court, even when the judge doesn't agree with them, gives them the sentence or the outcome that we told them that was going to happen, because the judge listened to them and reflected back and was respectful. They really appreciated what that judge did, and as a result, followed the law, you know, when you feel like you've been heard. So empathy and kindness, I think, are part of those.
Mr. Reetz.
No one has ever credited me with being the kindest person they ever met. Ever. I don't blame them. Empathy, sympathy, compassion, those are all noble things, and it is an important part of not just being a judge, but being a lawyer as well. It's why you get into this business, as gruff as lawyers seem and as tough as you might think you are, or other people think you are. As movies, the judges are always tough in movies and everything, but beneath that is a true compassion and caring for the human being, for humanity. And it is imperative to have that quality to be empathetic to people before you. These people are at their worst. They're at their worst. And at that point in their life, a lot of them don't understand, don't know, and won't believe that their lives can get better, that they can improve, that this is their bottom, and there is hope, and there is possibility, and there is opportunity, whether it be putting their family back together, whether it be getting through a criminal matter and rebuilding their life, rehabilitating their life. All those things, the underpinnings of all those things, rehabilitation, success, overcoming difficulty, all those things have a foundation which is built in part with empathy, sympathy, compassion, caring. So as a judge, sure, you can be hard, make hard decisions, make tough decisions, be forthright. But beneath that, you need to be able to convey that you truly care, that the basis of your tough love is empathy and consideration for that individual. Because one of the thing that really does drive me the most in life is the amazing thing about human beings, that we can overcome adversity. We can be in the place where we think the world is ending, and yet if we have hope and faith and work ethic and belief, we can get beyond that and hit something in the lines of triumph. So that's my take on empathy. Thank you.
Thank you. Candidates, you now have up to 3 minutes for your closing remarks, and we will begin with Mr. Reetz.
All right. Thank you. It's really an honor to be here tonight. I'm very passionate about my goal in life and what I do. I've practiced law for 32 years. I've been a trial lawyer for 32 years. I have tried, as I said in my opening, approximately 50 jury trials. I have been in appellate courts. I have argued in person in the Supreme Court of Wisconsin. I've been in federal court in Chicago. I've been in federal court in Green Bay. I've litigated cases in Michigan. I've litigated cases in Florida. I've been in a tremendous amount of courtrooms, and I have a tremendous amount of experience with judges and procedure and law and juries, probably more so than any other private practitioner in Door County at this time. I've basically checked all the boxes off as a lawyer. Next. But that's not all it is to be a good judge. I didn't go to law school or college and law school right out of high school. When I was 19, my father went bankrupt, and what we thought was pretty stable middle-class life was anything but. From then on, my sisters and I were on our own financially. My parents never stopped loving us. So we worked our way through school and degrees. I worked construction until I was 32 years old, my last semester of law school, and I didn't own a suit or know any lawyers other than my professors until my last semester of law school. I went to night school and undergrad and DePaul University Law School. I have been poor. I have struggled. I have lived life. I have struggled with children, my children. I have struggled to pay bills. I've lived the life that makes me no different than anybody else. I'm nothing special, and maybe I'm less than special in some ways. The point is that that type of wisdom, that type of life experience prepares a person to be a good judge. It's not enough just to know the law. It's not enough just to know the procedure. You have to have those life experiences because that allows you to understand the people in front of you, the parties in a lawsuit, the lawyers. You can understand a construction case. You can understand a family law case. You can understand how a child feels when his parents are getting divorced. You can understand how a parent feels when they're losing their children. You can understand a mother or a father who've lost a child. You can understand a person facing prison, and you can understand the normal. It gives me the ability to understand a normal person's life. Combining that experience, that practical experience, with my legal experience, I'm confident that I can become a fantastic judge on par with the 3 judges sitting in the room tonight. I'd ask you for my vote, or for your vote. Thank you.
Ms. Miller.
Thank you. Shortly after I became a court commissioner and realized that I enjoyed the work and that I was well suited to it, I was paying attention to what other judges were writing about their work. One that spoke to me is a Barron County judge and a Washburn County judge at an investiture, the ceremony where a judge becomes a judge officially. And the one judge advised the other, never forget that you're here to serve, not be served, to always treat others with dignity and respect, and never miss an opportunity to season justice with mercy. And then last week, I was at a presentation about words, how words matter, the words that we use. And somebody made the comment about the variation of human experience and appreciating that it's their lives, not an agenda. And it really spoke to me that the people that come into the courtroom, it's not about me, it's about their life. That's what I've been trying to live, trying to strive for as my work as a court commissioner. I've had the experience of being a court commissioner for 13 years and then my legal experience for 17 years, but some other ways that I've been involved in judging as a police and fire commissioner for 9 years. 7 of those years I was the president. I was elected president by my peers. It was a quasi-judicial proceedings at times when the chief of police a couple of times had to bring charges against an officer. I was a mock trial judge and coach. I did guardian ad litem work. I was really honored when judges would appoint me with that important job of representing the best interest of a child in a family case or of somebody alleged to be incompetent in a guardianship case. That was a situation of being in the middle of people in emotional cases. So all of those things prepared me very well for being a judge. And as to service, since I moved to Door County, I've been involved in a number of nonprofit organizations. One time we went on a retreat, and we all were supposed to talk about each other, write down on a piece of paper different qualities. And this is what my fellow board members who elected me chair of that board said. They said I was careful. They thought of leadership, organization, that I was focused, had depth on issues, supportive, critical analysis, and balance. Thank you for coming this evening. Thanks for listening.
Thank you. Thank you, candidates, for participating in tonight's forum and for serving if elected. You are invited to remain for a few minutes after the forum to give the public the opportunity to meet and visit with you personally. Thank you, audience and viewers. This was a wonderful, wonderful turnout, great questions. We hope this forum has been helpful to you as a voter. Remember, the general election is on April 2nd. Current voter and election information can be found on myvote.wi.gov. There you can access information about voter registration, updating your name or address, absentee voting, polling locations, and what's on your ballot. Thank you all for attending and participating. Please let others know they can view this forum at www.lwv-county, all one word, .org. Thank you, candidates. Please join me in a round of applause for the candidates.